I want to welcome you all to this special session on the African Continental Free Trade Agreement, and in light of what's happening with the COVID-19, to discuss whether the agreement is dead on arrival or whether there is still life left in it. It is my distinct pleasure to welcome a panel of discussants who are ably and eminently qualified to do justice to this topic. And in no particular order of importance, I'd like to welcome Professor Anne Flanagan. You're welcome to the session, and I'll give your bio data later. I'd also like to welcome my good friend, Victor Liman. You're welcome. Victor is the Chief Trade Negotiator and the Director General at the Nigerian Office for Trade Negotiations. I also see Ms. Leyu Tameru. I hope you can hear me now. She's Ethiopian and is a legal consultant and founder of the IARB. Essentially has to do with arbitration in Africa. I'm expecting Mr. Fidelis Adewale. Unfortunately, we cannot be joined by Ms. Yewande Sadiku. She's the Executive Secretary and CEO of the Nigerian NIPC, the Nigerian Investment Promotion Council. She's had to deal with some emergency concerning her office, so she's unable to join us. If we're lucky, she might get us a representative. But with Victor around, I think you can cover many of the areas you and they would otherwise have occupied. Now, to start the ball rolling, the African Union in May 2019 entered into agreement to set up the free trade area with the key provisions that the area should be set up. There should be a protocol for the trading goods, the protocol on the trading services, the protocol on rules and procedures on the settlement of disputes. Now, the Nigerian Bar Association has, in fact, been engaging the National Office of Trade Negotiations and the Federal Ministry of Industry, Trade and Investment, whereby a committee has been set up to look at the practical implementation of this agreement. Now, to aid the liberalization of legal services, the profession itself set up an AFTA committee, which is actually chaired by Mrs. Mfon Ekongosoro, to look at how we can get Nigerian lawyers to participate in this area. Now, all plans are afoot and things are going on very well. But then we now have COVID-19, which is the great disruptor, as I call it. And the immediate response by many jurisdictions is to sort of look forward and go back to basics to find solution. From the United States to Europe, China, everybody is beginning to look more inward than outward towards dealing with the practical challenges posed by COVID-19. It is in the light of this, one begins to wonder what will be the fate of AFTA, especially as it pertains to legal services. So I'd like to welcome the panelists again, and let me formally introduce Anne. Anne is a professor in Queen Mary University of London, and you have a very, very impressive CV. I see that you have studied everywhere from St. John's, New York, to Brooklyn Law School, New York, LLM, Professor of Law and Legal Education at the Center for Commercial Law Studies, Queen Mary University of London. You're also the LLM Director at the Center for Commercial Studies. You do a lot in the EU telecoms area, do plenty of work in privacy and data protection. That is very key to what we're discussing. And then you have participated in which is very key, research and training projects for the European Bank for Reconstruction and Development, UNCTAD, and the EU. And I really kudos to the SBF to having fished such a very resourceful lady to help give light to this topic. So Anne, you're welcome to the 14th section on business law conference.
Thank you.
And thank you for agreeing to participate. Now, Victor Lehman, as I mentioned earlier to you, is the trade negotiator and director general at the Nigerian Office for Trade and Negotiations. Victor, your CV is so long that someone just whispered to me that you don't need any introduction at all. But I'm tempted to add the fact that you are an expert advisor in international investment and trade law, international finance and project finance, regulation, governance, technology law. Your educational background has taken you through any kind of studies one can imagine in this world, including nuclear and public policy, diploma in war studies. I mean, this is very frightening, Victor. But most importantly, you are doing a great job to ensure that AFTA becomes a reality, and we really and truly appreciate you. I know we had a 2-day workshop with you, with the NBA Special Committee, where you took us through. So thank you.
Thank you, George. Thank you.
Now, I will introduce Lady Tameru when she's able to join us. Her audio and picture appear to be a problem. But let me start with you, Victor, and then me put the question pointedly at you. Where are we today with AFTA in light of COVID-19? Victor, do you want to unmute yourself?
Yes, I'm already unmuted. Do you want me to start? I mean, I don't know. Okay, because I am sorry, the connection is unstable. It keeps going off and on. So if you lose me while in the course of the discussion, please pardon me. But I pray it stays on. Yes, AFCFTA, dead or alive. I would say a couple of things as a start. As you know, the AFCFTA came into force on the 30th of May, 2019. Just to give those who may not have been following it a bit of a background. It came on the 30th of May, and as you also can recall, Nigeria signed the AFCFTA agreement in Niamey, 2019, on the 7th of July, 2019 in Niamey, as the 53rd African country to sign the AFCFTA. And also as a background, as you know, 28 countries have both signed, ratified the agreement, and deposited the instruments of ratification. The depository, which is the AUC, that is the African Union Commission. And Nigeria is yet to ratify, even though we have signed. But as you also know, that there are domestic processes that we need to go through in order to then ratify the agreement. Perhaps I would like has not ratified up until this moment. We are hoping that, I noticed that it went off while I was...
Can you guys hear me? Sorry, Victor, we lost your my connection. So please go ahead.
Yeah, I think it's a connection. So I don't know whether everyone heard me when I was giving a bit of background about the AFCFTA. I said that the AFCFTA came into force on the 30th of May 2019 at the meeting of the threshold requirement of 22 member states that had both signed and deposited the instrument of ratification with the African Union Commission. So it came into force on the 30th of May 2019. And then Nigeria signed as the 53rd African country in Niamey, Niger, Republic of Niger, in 2019 as well. And as you know, also as a background, I also said that Nigeria has not ratified the agreement. One of the reasons why we can't ratify the agreement is that, as you are well aware, Judge, that we have a domestic process and requirement before we can ratify any international treaty, including the AFCFTA. So the reason that we may not have ratified till now may not be far from the present condition that we are currently facing, which is the COVID-19. So one is hoping that we would be able to ratify as soon as now, on the question of whether the AFCFTA is alive or dead.
Sorry, Victor, let me kindly ask all the other people to mute their phones so we don't have the echo that's going on now. Kindly mute.
Yeah, it's echoing, so everyone can...
There's an echo, so just mute, and when I call your name, you can then unmute. Thank you. Victor, please go ahead.
Okay, so please, okay, can I go ahead? Yes, okay. So the question of whether AFCFTA is dead or alive, it depends on how you view it. I mean, as an individual. But from a general point and from a general and objective point of view, of course, AFCFTA is fully alive. I'm just coming from an AFCFTA meeting. In fact, I had to cut off to join you. I had to cut off the meeting in the African Union to join you because I have already given you a commitment to speak here. Otherwise, I would have still been in that meeting. The meeting closes at about 4 GMT, that was African time. So I would have still been in that meeting, but I had to join you here. So on that note, I would say that, as you may recall, that the start date for the AFCFTA was slated for the 1st of July 2020, like 2020, which is this month. But before even the 1st of July, I think the pandemic started last year, although in trickles last year, 2019. In January, we began to see the negative effects of the pandemic across the world. Then in March, it became impossible that countries can still do business as usual. And then borders have been about 94 countries, 94 thereabout countries, they have activated export restrictions. And globally, borders have been closed. And globally, you have lockdowns restricting free movement of persons and free movement of goods, excepting for the movement of essential goods and also medical supplies, as well as essential staffs that are, or workers that may be engaged in essential duties, such as medical doctors, nurses, and of course, pharmacists and the rest of them. And so in Africa, currently we have about 42 borders have been closed. either partially or fully in Africa. And therefore, for us to have still decided to stay on course with the activation of trade, with implementation of, with the kickstarting of trade on the 1st of July would have been questionable. Because how do you kickstart trade under the circumstances that I have just described, where the mechanisms that drive free trade are in total, are either partially in abeyance or in total halt? You know, so the borders are closed, the ports are closed. You have air travels have been completely restricted across Africa, and free movement of persons have been completely restricted. Only recently people have started moving in Nigeria, as you know. So therefore, it would have been illogical to say, let's still keep to the 1st of July as the day to kickstart trade under the AFCFTA. I mean, because these are the mechanisms that facilitate free trade. And you talk about the NTBs, non-tariff barriers. Non-tariff barriers have become even more during this time that there are lockdowns across Africa and across the world. So you have countries who will not let you in to their country because you're coming from another country.
Now, you know, yes. I'm assuming and that the dream is.
Yes. Hello?
Can you hear me?
Yes, go ahead. Please repeat it again.
This is temporary.
Yes, of course, this is temporary. I mean, it's temporary.
The dream is still alive.
Of course, the dream is still alive. That's where I'm going. I don't know if I'm explaining too much. Maybe I should just give you bit by bit, and then so the output can come in. So the dream is still alive. It's very, very much alive. And what we are doing currently is that we are discussing on the opportunities that even the COVID-19 provides. The opportunities, although the situation is grim, but again there are lots of opportunities that we see with the advent of the COVID-19. One of such opportunities is that we have sufficient time for ratification of the agreement in Nigeria and countries that haven't ratified as well. It's an opportunity. And we have opportunities of looking at the workability of our institutions, readiness of our institutions. Are our institutions ready to trade, for us to trade under a free trade area arrangement such as the AFCFTA?
Okay, Victor, that's a good place for me to ask you to pause, keep your thoughts, and let me go to Anne. Are you there? Are you still there with us, Anne?
Yes.
Yes.
I think she's here, yes.
Yes, Anne, good. Yeah. Can you hear me, Anne?
I can, George.
Great. Now, you've done a lot of work for the EU, and no free trade area has a better example to follow than the EU. I still recall in my days at the London School of Economics, we did a lot. At the time, it was the EEC, and we then metamorphosed into the EU. Now, practically, what advice would you give to the African free trade negotiators? Are we moving too fast? What can we learn from what Europe has done?
Practically speaking, I think that every region, every agreement has to meet the needs of the member states.
Sorry, we can't hear. Okay.
And so one of the things that I think you need to take into perspective is it was 70 years ago that the EU began its initial construction of a single market in a war-torn continent of former enemies. And so it was a gradual accretion of different focuses over time with the turning to and adjusting by the member states and by the institutions as needs developed. So as freedom of movement in order to facilitate the economic aspects of the single market developed, you saw the overlay of things focused on the rights of citizens and actually the status of citizens as not only citizens of their country, but citizens of the EU. And so it wasn't all a slam dunk, upfront, done deal. It was things that evolved over time. Now, Africa is not, in the same position, and you've got advantages perhaps that even the EU didn't have back then. So I think you recognize the great potential that comes out of this, and you build it your way, looking to take as much from other institutions as you can. I mean, it's very possible right now that Africa could be the leader at another, the World Trade Organization. You have several African candidates who are possible serious contenders. And so, you take from best practice where you find it and you develop it, you emulate, but you have to do it. You can't take something wholesale, a framework, even a fair trade agreement without considering the individual needs and bringing people along. Now, I realize that it requires people to think multilaterally rather than just nationally, and that's stuff that takes time, but I think the opportunities there are very great.
Okay, great. Thanks Anne, for that, those very encouraging words. Now, I want to bring it down home. And if we're going to liberalize trade in services, which includes legal services, the concern will always be that of dominance. There are various modes by which these services can be rendered. You can fly in and fly out. You can set up your offices in any target country. You can even apportion areas where you can practice. It all depends on domestic regulations. Now, I don't know, Victor, I know you've been talking to us at the Nigerian Bar Association, and we've been expressing our concerns because this is not just within the African Continental Free Trade. Also, if not also with GATS, with the agreement of trading services, if you can hear me. And our concern has been, to what extent should we allow foreign legal services to participate in our market without some form of regulation? Now, as a trade negotiator, how are you addressing these fears? How are you dealing with the issues that are on with you? Some say the large African countries, the larger ones, would dominate the market. And I know we're getting the pushback from the smaller countries. There are also the concerns about foreign law firms who cannot go into markets today, going through smaller countries, similar to the fears expressed by Mann and Co. when it comes to goods. So, Victor, what are you people doing? I'll come back to you, Leyu. Can you hear me now, Leyu? Good, great. So let me talk to Victor again. Victor, if you can expatiate on that, and then I can come to you and say, Leyu, let me know what's happening on the arbitration end of it. Okay. So, Victor, back over to you. You need to unmute yourself. We're having problems with the audio.
Can you hear me now?
Yes.
Okay, excellent. Okay. As you know, Judge, there are 4 modes. There are 4 modes of supplies when it comes to the trading services. But before I go into that 4 modes of supplies, I want to cast your mind to the protocol of trading services. We have a protocol of trading services, which of course came into force alongside with the main framework agreement itself in Kigali. That was in Kigali in 2018, on the 21st of March, 2018 in Kigali. So currently we have been working on the schedule of specific commitments on trading services. As you know, during our consultation, we consulted with the legal professionals through the Nigerian Bar Association, as well as other business bodies and professionals, including accountants and those in finance, as well as fintechs. Now, there are 5 key areas, or what we call priority areas, that we would liberalize initially. Those 5 priority areas are the business and professional services, you have transport, you have tourism, and you have finance, and then communications. Those are 5 key sectors that we would initially liberalize out of the 12 major sectors that are in services. But to go to your question directly without taking much time, we have various modes. Mode 1, consumption abroad. Mode 2, cross-border supplies. And mode 3, which is the commercial presence. And then mode 4, which is the presence of the natural persons. Now, as you know, we also have what is called horizontal commitments under the AFCFTA. The horizontal commitment speaks to the regulations, speaks to the policies, speak to the legal requirements that either a body corporate, that is a company, would be required to fulfill before setting up shop in Nigeria fiscally. You also have regulations and you also have laws governing mode 1 and mode 2 operations, and then particularly mode 4. Now, in order to be able to enter into our market, we need to first of all open up that particular mode for you to come in. As you know, under legal services, what we've done under legal services is that we do not have any form of commitment under legal services from mode 1 to 4. We've totally closed that. At your request during a consultation with the NBA. So that, and one of the things that we looked at was that in Nigeria, there is a legal requirement that you have to go to the Nigerian law school before you can practice law in Nigeria. And to that extent, therefore, for you to come in as a lawyer to practice in Nigeria with the AFCFTA framework, you need to have been able to go to the Nigerian law school. Having said that, Judge, you also know that under the AFCFTA, we are also looking at mutual recognition of qualifications, right? So, but with regards to legal, it will be difficult for us to mutually recognize South Africa's bar qualification and Nigeria's bar qualification. It will be a bit difficult because the legal frameworks varies. And also when you go to, say, for instance, Senegal, the legal framework varies in Senegal and some other countries. So it would require then in the individual legal practitioners to come into Nigeria and then negotiate with the NBA. And in the course of negotiating, they would also need to look at the legal and the regulatory requirements or the policy requirement that they need to fulfill in order to be able to establish in Nigeria, in addition to going to the Nigerian law school to qualify to practice in Nigeria.
Hold your thought.
Hold your thought. All right.
I see the point you are making. But if I'm going to particularize it to business law, is there an argument for the harmonization of business laws in Africa as a means of sidestepping this difficult requirement? But before you answer that question, I want to now go to Leyu Tameru. Ms. Leyu Tameru, are you there now? If you are there, I'd like to engage you on the subject as it pertains to arbitration. We've been having some difficulty with connection from Ethiopia. So whenever she comes, I will throw the question at her. But let me get back to you, Anne. Are you there, Anne? How easy is it for EU country members to practice their laws in each other's jurisdictions? Can a UK lawyer, for example, the UK is opting out now, say a German lawyer, for example, just walk across to France and practice without any further ado? How is it done in Europe?
Well, there is an EU lawyer qualification that allows you to practice in another jurisdiction, but with reference to your own training. And so there isn't great ease of trans-border provision under many modes. In the UK, for example, when it was part of the EU, you could be hired by a firm and work as an EU lawyer, focusing on areas where you had expertise. So you could also then, and I think this is, for me, the issue is, have you got the level of expertise that you need to have in order to be able to practice and ensure quality of services and integrity of services. So do you need to go to a Nigerian law school to learn Nigerian law? Probably not. So, but in the UK, for example, you could, and the criteria are changing, you could study and test and qualify based on knowledge and skills and become a solicitor. And so there are ways. I think in many instances you find that some of the requirements in the individual member states are, well, they're market protectionist for reasons, including to ensure expertise. So it's not it's not that impossible to qualify, but you could to qualify in Germany as a German lawyer, it takes like 7 years. So that's not readily done.
Okay, Anne, let me ask, has COVID changed anything regarding this? For example, I know even during the lockdown, different EU countries had different rules for opening up. Has COVID changed anything?
Did COVID change anything in the EU?
Yes.
No, clearly physical borders were shut, as Victor pointed out, akin to what was done. There are travel bans, which clearly fly in the face of free movement under the EU. So yes, it has changed things, whether these are permanent changes or the temporary emergency suspensions to protect citizens' health and safety. I think that's the distinction that we can make, because borders are opening back up. Travel is being allowed to the extent that it's safe. So I don't think it's a permanent change.
Okay. Fidelis, welcome. We missed you.
Thank you.
But I'm sure you've been following the discussions. And from the perspective of a Nigerian lawyer, I see that you went to the great Ambrose Ali University. You do a lot of work that covers litigation, taxation, M&A, and you're a member of the Chartered Institute of Arbitrators UK and a fellow of the Chartered Institute of Taxation in Nigeria, and you're also a notary public. That's power packed. Now, do you feel threatened if our borders are opened up to foreign lawyers? Do you think we can benefit if we open up our borders? We are producing about between 6,000 and 8,000 lawyers every year. And the word out there is that we're not taking good care of them. So should we allow people to come and fish in our waters? Or do you think it can be the other way around? Can we export legal services to the rest of Africa?
Yes, I think it will do us more good than harm if we open our legal practice to the entire continent, and also we allow to also practice in their own countries as well. Don't forget that economy thrives on numbers. As of today, the total population in Africa is over 1.3 billion and is still growing. It has been estimated that Nigeria will grow in the next 30, 40 years to over 300, 400 million. So I think opening our borders and our legal practice to non-Nigerians will actually be beneficial to us. As if you look at the legal markets, for instance, the most developed legal markets in Africa, we have to take Nigeria, South Africa, and maybe Egypt. So the rest of Africa, yes, they are growing, but they are not as developed as we do have here in Nigeria. So if we allow our legal practice, with rules and regulations in place on how to be called to Nigerian bar, having the necessary skills, going to the Nigerian law school, that will be helpful, and Nigerian lawyers will have more markets rather than just streamline our market just to Nigerians alone. We need to open up.
I hear what you're saying, Fidelis. But meeting the local requirements for practice may not be enough. I recall that Ghana, our neighbors next door, used to allow that happen. And in little or no time, their law school was flooded with Nigerian lawyers, and they shut it down. So we are just as much a threat when it comes to exporting legal services. And I worry that if we don't have a way of a win-win solution for everyone, that this might be a pipe dream. Do you share that view?
Not really. I would say for what happened in Ghana is just because, as you said, it is not a win-win situation. This is a situation whereby Ghana opens up, and none of the African continent, apart from a few, also opened up their legal market as well. So under this agreement, if we are able to allow all state parties under this agreement to open up, so I can be, if I'm willing and happy to become practice in South Africa, I will be allowed to also South African lawyers too will be able to practice in Nigeria. So it's a question of reciprocity rather than just blocking it.
Okay. Now, I said you should know your thoughts on the harmonization of business laws, because like you identified, the practicality of cross-border legal work in Africa will be impeded by the various domestic rules for qualification. But business laws tend to be universal in their application. And we know that under the OHADA initiative, the Francophone speaking countries have managed to harmonize their business law and therefore facilitate movement of legal services amongst them. Can we make the same case for under AFTA? Should we not use that as a model, Victor?
Again, Judge, yes, you're right. But even within the OHADA, just as an aside, even within the OHADA, there are some legal challenges within the OHADA. So you still have those challenges. Having said that, within the AFCFTA, what we have done is to work towards the regulatory harmonization as well as policy harmonization, and then a mutual recognition of qualifications. Now, as you know, in trade and services, in the negotiation of trade and services, the process is a request and offer process. So you request from a negotiating party, you send a request to them, or either to a negotiating party, either individually or as a group, and say to them, this is what we want from you. We want you to allow our lawyers to practice it here, or we want your lawyers to practice here. Now, that's how it works. However, in terms of harmonization, what we are doing is to we are also working towards negotiating a protocol on competition policy. We are working towards the negotiation of sustainable investment protocol. So when these two protocols are in the competition policy and then investment, sustainable investment, there would be some kind of harmonization. Apart from these two protocols that we hope will be put in place during the second phase of negotiations, we are hoping that the regulatory yet to be done regulatory and policy harmonizations would, of course, harmonize some of the divergences that you have pointed out within our business law framework, be it in Nigeria or be it anywhere else in the world, or be it anywhere else in Africa. But let me just point this out to you. As you know, there is already some level of cross-border practice and consumption abroad when it comes to legal services. Of course, you're aware of this, that you can stay in Nigeria and give legal advice to someone in South Africa. I'm sure Josh has been doing that. Even without the liberalization framework that we're working to finalize. So that has already been going on. Like Fidelis said, there would be more to gain. But I think in order to ensure that some of these divergences and the teething issues that would make it difficult to implement all of this, I think countries or group of countries, whether as ECOWAS or as SADC, as SACU, or as the OHADA you mentioned, would need to sit together and agree amongst themselves as to what they want to do. Because yes, we are liberalizing trade in services. We are liberalizing 5 sectors of services within Africa. But again, it will also, in the end, it will depend on request and offer between countries, either between 2 or 3 countries, or either between say ECOWAS and SADC, or COMESA and any other REC within the region.
Okay, thank you, Victor. Let me stop you there. We have 15 minutes to round the session up, and I would like to throw some questions that have come from the chat box. And let me thank Kehinde Daodu, who is coordinating the session. I've told him that he's a Kehinde like me, so we gelled right from the outset. Now, one question that has come in is, the AFTA Secretary General has proposed a trade corridor to facilitate swifter clearance of essential goods. What are your thoughts on the practical aspects of implementing this initiative? Victor, I'm sure you can naturally throw that. And then Anne can probably let us know what's going on in the EU.
As you recall, at the heat of the COVID-19, Nigeria in particular, through the Federal Ministry of Finance, actually came out with a list of moratorium, if you can recall that, and suspension of tariffs. So even before the AFCFTA Secretary General made a proposal, Nigeria had taken steps to ameliorate and to address the sudden shutdown of supply sources and the limitation of supply sources. Now, in terms of what the AFCFTA Secretary General said, that is doable. That is a possibility. In fact, like I said earlier on, the COVID-19 provides a once-in-a-lifetime opportunity for Africa to actually, build capacity on across a broad range of issues. Africa is cooperating more, even currently. Africa is trading more with itself currently because they have no option. They are buying more, and Africa. You can also attest to this. That in Nigeria, I mean, we have ramped up the production of PPEs. 7 companies, I'm told, immediately diversified its product line and started producing PPEs immediately. And as you know now, PPEs are no more, and they are not a problem only in Nigeria. The only problem that we have with PPEs in Nigeria, it would have to be with standards and quality, as well as specification. Those are the issues we have. Bearing that, I think we've ramped up, and so the trading corridor that you are talking about is already in place. Although, okay, all right. Okay,
let me thank you. I want to with Victor Bochi's question. What is the role of the regional economic communities in the build-up of AFTA, and will their current initiative be included as an investment in overall capacity development of AFTA? Victor, that's to you again.
Oh, excellent. Okay, that's actually that question. They flow into each other. Yes, as you may recall, that the AFCFTA is as a result of what we had done right from when we had independence. However, we limit it to the Lagos Plan of Action of 1980 or 81 or thereabout. Now, that's the Lagos Plan of Action, and then to the Abuja Treaty of 1991, and then we culminated into where we are now. Now, within the AFCFTA arrangement, we agreed that in order to make the negotiation, much more, less difficult, less complex, that the rates would form what we call the keys or the foundation for the AFCFTA. So the rates are the keys or the foundational framework through which the AFCFTA is negotiated and agreed on. For instance, let me give you an instance here. Under the AFCFTA, ECOWAS, we are currently negotiating as a bloc the schedule of tariff of goods on market access. We are negotiating that. That schedule is almost ready, and we've achieved almost 93% completion of that.
All right. Now, like many lawyers in Nigeria, we worry about how our teeming population of young lawyers can benefit from the opening up of legal jurisdiction for cross-border legal work. Now, how do we deal with the enforcement issues that will arise from the fragmented laws? We're talking about laws that are not harmonized, and if we allow this free movement of trading goods and services, how do we deal with the issues that come with it? Fidelis, are you still there with me?
Yes, I'm here with you. I can hear you loud and clear.
Okay, please go right ahead and answer the question.
So the issue regarding, I think the way it will operate under the agreement is different from the way it is it's currently being operated under our national laws. Issues relating to enforcement or to dispute will have to be dealt with at the initial stage by the parties, and they are allowed to discuss amicably and to see how they can resolve any issues that they may have between or among themselves. But as far as the dispute or enforcement issue is concerned relating to the agreement, parties are not allowed to approach the dispute resolution mechanism under the agreement. What they need to do is they have to go through their parties, to their governments who are state parties to this agreement to resolve any issues that they may have under the agreement. So if and when implemented the agreement, yes, state parties, as we have under our current law now, we have to harmonize their laws to see that legal impediments are removed, if any, and that if there are issues that need to be resolved, then you approach your government through which you can resolve any issues that are arising under the agreement.
Thank you. Now, let me come to you. Again, I want to draw on your EU experience. Is there anything we can learn from how disputes are resolved? How all these issues of, well, in the teething phase of the establishment of the EU, is there anything we can learn from you on the subject? How do you deal with dispute resolution arising from cross-border legal work?
Cross-border legal work, what was developed was, as I said, a set of EU harmonized principles to allow for cross-border delivery and work, but there is no, every single jurisdiction, you have to go through their criteria. So in that regard, harmonizing frameworks, no matter what the framework is based on agreed principles, core principles, and then you have to decide what's your minimum harmonization, your maximum harmonization, and that achieves the objectives that you want to achieve from a policy level. So, you know, we see big firms operating, and you've got some, you know, good-sized firms across the continent. And so it's a matter of meeting the threshold eligibility requirements or achieving, looking at the EU lawyer model qualification that recognizes, so you have to be qualified in your own jurisdiction, and then you're able to practice and provide guidance in that area across the EU. So harmonization is not an easy thing, but that's for law practice. But in the business arena, I think there are so many areas. Who was it? Fidelis, who suggested that business laws have many universally acknowledged principles, and so when you're looking to minimize disparities, I think that's a good place to start. In terms of cross-border practice, perhaps you could look to the US for a different model. So they have agreed, the states have agreed to a multi-state bar exam that tests for core legal principles and their application. And then states add in their own mini bars to particularize the exam to the California qualification or the New York bar qualification. But most states now have put in place an agreement that they will accept the multi-state on ethics, on the different topics, which governs areas of law. So maybe satisfying that higher bar across the various countries would be enough to give people assurances that a level of harmonized expertise had been achieved, which is really the goal of having qualifications and minimum educational and knowledge-based requirements for the practice of law.
Thank you. And I see our chat box is very active, and I see Mrs. Usoro, Nella, and Ewa Rabana. I can also see other comments, but one of them says several issues need to be considered and supported by member states. What will be the selection criteria for establishing the trade corridor? Victor, this is definitely for you. On another level, the infrastructure and platforms, say water transportation, for example, land. And somebody mentioned the railway that's been, railway projects that have been undertaken by the Federal Ministry of Transportation. How will all these help for facilitating trade within Africa? And Victor, you have 1 minute, and you also give us your rounding up remarks because we're out of here in 3 minutes. Go ahead, Victor.
Okay, then first of all, you have the ETLS in place. The ECOWAS liberalization, the ECOWAS liberalization scheme. You have that in place. So within ECOWAS, it's not a problem because you already have a tool or an instrument that allows for trade to take effect, whether during COVID or non-COVID. But for other member states across the continent, you would also require this kind of instrument that you have in various realms. Because I know that SADC also has this instrument. SACO is also a custom union. So there's a level of free trade that goes on amongst them already. Where we would have a problem would be maybe when you talk about areas such as North Africa and then trading with West Africa. Those are that. But even at that, I mean, the African heads of states and government can come together and agree, or the various body of the AU institutions can come together and agree on what to do.
10 seconds. Give us your rounding up thoughts. So I know where you stand. We should open up. So you see a bright future for Nigerian lawyers, especially the young one. 10 seconds. Please unmute yourself.
Yes, I think we benefit more, as I said earlier, if we open up our economy to this policy of economic integration with other African countries. We cannot compare a population of 250 million Nigerians to a market of over 1.3 billion. So the difference is huge. So we have to benefit a lot. Notwithstanding the fact that we pride ourselves as the giants of Africa. So we can close our eyes to what is happening to the rest of Africa.
Okay, thank you. And what are your thoughts?
Well, I see some questions from the audience regarding a very interesting area about standards and the use of standards as market protectionist, including in interfaces for computer, all different kinds of services, transport, rail widths. This is a key area that we've seen global and regional areas, forums to address it. In the EU, for example, until they took on putting in place a neutral body that addressed the development of standards that you could use to take down the cross-border barriers, that wasn't achieved. It had to be removed from, for example, the national monopoly providers to ensure the upgrade of services and the interoperability of services. So
sorry, I'm going to have to cut you off.
It's a multi-phased, complex thing, but you have to do it.
Thank you all our wonderful panelists, Fidelis, Victor, and I'm afraid we couldn't get Leyu Tameru from Ethiopia. We had audio and picture issues with that. But this has been a very lively session. Victor will continue to engage you, Nigerian Bar Association, and we all hope for the best under the African Continental Free Trade Agreement. Thank you all for being
Thank you for the invitation. It was a pleasure.
Thank you.
All right.